everybody's a good public speaker. They talk to their attorneys. They're usually advised on that. But the main thing is that you would not say, well, he must be guilty because he didn't testify. Ultimately, that's what the law says.
Can I request a reporter for the hearing?
I have a court reporter.
Okay, great. I didn't see you there. I'm so sorry.
Y'all come on up if you would. Ms. Magruder, come stand on the end. Good morning, ma'am. You're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder's here with her attorney, Mr. Bynum. Ms. French is here on behalf of the state. Ms. Magruder is on probation and cause number 16-25158 for the second-degree felony offense of sexual assault of a child, was placed on that probation January 29th of 2018. We were previously in court and Ms. Magruder entered pleas of not true to counts 1 through 5 of a motion to revoke unadjudicated probation. Case was set for a hearing today for sentencing. I have received and reviewed the pre-sentence updated report. Have you both had an opportunity to review that report?
I have, Judge.
Yes, Your Honor.
Are there any corrections to that report?
None from the state, Your Honor.
Judge, I would like to make some objections to the report, but if I may, I'd like to also point something else out to the court. This morning, I filed a application for a writ of habeas corpus under Article 11.072 in this case, and I have a courtesy copy for the
I
court.
have a copy of it.
So
I don't think this is the appropriate time for that because Ms. Magruder is on a deferred probation and there is no conviction, if I'm correct, for this type of argument. I think if she were to be found guilty and her probation revoked, I've reviewed it. If I can rule on it if you want, or I can hold it and then, I mean, the gist of it is that you're saying that trial counsel was ineffective and that her plea was not knowing, voluntarily, and intelligent. Is that correct?
yes, Judge, and in addition that there's an as-applied constitutional challenge in ground one regarding the strict liability. If I may, if this case were to result in a conviction, then that the proper habeas vehicle would be Article 1107. But since it is still a community supervision case as of this morning, the proper vehicle is still 1107-2. And having filed it at this time, I believe that the court's issuing the writ, which the proposed order is on file, is mandatory, and that even if the case were to proceed to an adjudication and even a sentencing today, that the 072 matter would remain open and need to be heard.
Your Honor, may the state be heard?
Yes.
I've talked with our appellate chief, and she's not received any notice of this 11072 writ application. That would be appropriate for the appellate division to see and respond to before there is any testimony or argument regarding that application.
So I just received this morning. We're set for sentencing today. What I'm going to do is hold that writ. I'm not going to rule on it. I'm going to give the state time to prepare for any writ. I will have our counsel take a look at it as well. And if at that point I require any affidavits or testimony, we'll get it set for the appropriate hearing at that time.
Okay, thanks, Judge. The only other housekeeping matter is, and I have a paper copy if the court would like, the order issuing the writ of habeas corpus is a mandatory. It doesn't create any relief or anything. It's just that is the mandatory statutory provision to begin the process. And I would ask the court to.
I'm not going to sign that today. Again, I'm going to take a look at it when I have more time before I sign any order that I haven't had an opportunity to review the entire writ. Look at it with my counsel that works for the courts before I sign anything. So again, I'm going to hold that. I'm not going to start any process at this point. It was filed today, just a couple hours before the hearing. So I don't think it's something that I've been in court all morning. I haven't had a time to take a look at. Ms. French has not either. And so again, that's going to be just on hold. I'm not taking that up at this time.
Your Honor, may I be heard on one more matter?
Yes.
I was in court at 9 o'clock this morning for docket, and sometime maybe around 10:30, 10:20, I happened to look at my email on my cell phone to find that there's a motion to compel discovery and for in-camera review of the state's file. And the only thing that I would like to address regarding this motion at this time is that it refers specifically to the 11.072 motion and appears to suggest that the state has not complied with discovery. And this is a motion to revoke probation. I did provide discovery to the defense counsel on the motion to revoke, as well as the administrative hearing, which I'm not generally required to do, but I do to be helpful. And also the pre-sentence investigation report. So I would also like time to respond to this motion to compel. As I said, I just briefly skimmed it, but those items stood out.
Well, based on the state's, I guess what I don't understand, Mr. Bynum, is why this is being filed today. We're here for a hearing. We're going forward with sentencing today. Ms. French has represented to the court that she has provided discovery with regard to the motion to revoke, which is what we're here for today. There's already been a plea on that underlying offense, and so we're going forward with the motion to revoke hearing on sentencing at this time. I'm not going to sign or grant any motion to compel. It sounds like they have already complied with everything they're required to do, plus some, to give you whatever information you need with regard to going forward with this hearing. So we're going to go forward.
Can I be heard about that, Judge?
Yes.
So the argument in the motion to compel is twofold, right? And I can tell the court, like, since it's an unadjudicated case, I believe that the standard discovery rules apply, and discovery is not limited to just the administrative documents and the matters regarding the motion to adjudicate guilt or the motion to revoke unadjudicated probation. That, you know, she is here being sentenced on the underlying offense, and I'm asking for discovery regarding the underlying offense, which I still haven't been provided. So my objection to proceeding today would be that on this ground would be that I have not received discovery after a request of the offense that we're here for sentencing, and that I think that the Morton Act requires that. The second fold argument here is that in 11072 habeas matter, which at this point is on file, that I have an additional ground that creates a discovery obligation in the state, since it is an 072 matter, contrasting that to 1107 matters, which have their own kind of scheme to replace.
Here's what we're not going to do. We're not going to go forward again on any 11072 matter today, or anything that was filed 2 hours before the hearing. And so we're going forward. You've been provided the updated pre-sentence report. It sounds like you were provided the original pre-sentence report, as well as administrative hearing and other information that Ms. French is relying on with regard to the hearing that we're here for today. The pre-sentence report that you received from before does have the police and court version. It has the defendant's version. It has a statement of interested parties. So you have already some of that information, in addition to, obviously, I'm sure, visiting with your client. So at this time, we're going to go forward. Ms. French, you may call your first witness.
Your Honor, may I respond to one thing to
Sure.
give court notice of? In 2016, Councilman Aldwin Samuel, not Councilman, Counsel Aldwin Samuel was the attorney for Ms.
It was
Magruder.
actually Mr. Sean Samuel.
Oh, Sean Samuel.
Mhm,
I'm
that's
sorry.
fine.
I saw Samuel very quickly. Sean Samuel was the attorney for Ms. Magruder. And I did check to see that he received the media in this case and signed for it. And while I did not have time to also search for an email stating that he had received discovery in 2016, which doesn't show on our current system. The state would point out that she did have the benefit of counsel who did receive discovery under 3914 in the original case. Now, I do understand that Mr. Bynum is trying to make law on this 10-year-old plea of guilt and deferred adjudication order. I would feel more comfortable, Your Honor, if we address these things before we have a sentencing hearing, but I'll do what the court would like to do. I feel there are allegations that should be responded to by historical document. I'm also guessing that somewhere in the court's file of this matter, there is a discovery certificate showing discovery was given under 3914 in the original case. And that would be important to note. I'd like to be able to gather certified copies of those documents in a written response to these motions.
Just a minute. Because this plea was taken before we had our current system, I'll have to look and see. But we had those certifications like we do now. I mean, they certified during the plea. But all right, so here's what we're going to do. Ms. French, I don't disagree. I want to give you time to make sure, and obviously time for me to make sure that there's nothing that we do today that would get us reversed and us be right back here. So I'm going to reset the case. I'll give you guys a date. Ms. Holmes will send that date out. I'll take a look at everything and then we'll go forward in just a few weeks on that. All right, Ms. Magruder, you can go back with the bailiff. And I'm also, once you get that date, for the hearing, I'm going to order at this time that any motions that either of you feel necessary to file must be filed 7 days prior to that sentencing date or hearing date, whatever it is. There will be nothing that's taken up that is not filed 7 days prior to that court date. All right.
And Judge, could I just tell the court I'll make whatever accommodations I can, except the last 2 weeks of May. I have some inflexible travel.
If you'll just make sure that you have filed a vacation letter with Jefferson County. So when Ms. Holmes does the reset, that should pop up and she'll see it. Otherwise, there's nothing I can do. So make sure you get that filed today. All right, Ms. Magruder, you can go back with the bailiff.
Have you ever watched someone walk into a courtroom believing they can outsmart the judge with clever wordplay instead of answering simple questions? That's exactly what happens in today's courtroom, and from the very first seconds, the tension is impossible to ignore. The judge begins with a straightforward request: identify yourself. But instead of cooperating, the defendant repeatedly dodges the question, challenges the court's authority, and tries to derail the hearing before it even begins. What follows is a fascinating battle between patience and defiance. Rather than losing control, the judge calmly shuts down every attempt to distract from the real issues. Every interruption is met with professionalism, every excuse with a firm reminder that the courtroom operates under rules, not personal theories. As the hearing continues, the defendant faces serious felony allegations involving assault and injury to a child. Yet instead of focusing on the charges or preparing a legal defense, he continues playing semantic games, insisting on unusual wording and refusing to communicate normally. The judge recognizes exactly what's happening and refuses to let the hearing turn into a performance. But that's only the beginning. Throughout this courtroom session, you'll see multiple defendants facing very different situations. Some are honest about their mistakes. Others struggle to find attorneys. A few receive second chances through probation agreements, while another accepts responsibility for a crime that results in a decades-long prison sentence. Every case highlights a different side of the justice system. Stay until the end, because this courtroom is filled with unforgettable moments where cooperation earns opportunity, excuses quickly run out, and every decision reminds us that respect for the court can make all the difference.
All right, let's go.
After watching this entire courtroom session, one message becomes crystal clear. Judges are willing to be patient, but patience is never unlimited. Throughout these hearings, the court repeatedly gives defendants opportunities to hire lawyers, explain their situations, and comply with probation conditions. Those who communicate honestly often receive additional time or alternative sentencing. Those who ignore instructions or refuse to cooperate place themselves in a much more difficult position. One of the most memorable moments is seeing how the judge remains calm even when challenged. Instead of arguing emotionally, every response stays focused on the law and the defendant's legal responsibilities. That professionalism keeps the courtroom moving while making it obvious that clever language cannot replace legal compliance. This session also reminds us that every case carries real consequences. Deferred probation, prison sentences, bond conditions, restitution payments, and mandatory treatment programs all show how seriously the justice system approaches accountability. Whether someone receives another chance or faces severe punishment depends heavily on their actions inside and outside the courtroom. Courtrooms aren't about winning arguments through attitude. They're about facts, evidence, and following legal procedures. That's why every hearing becomes a lesson in responsibility, preparation, and respect for the judicial process. If you enjoy real courtroom breakdowns, dramatic legal moments, and detailed commentary that explains what's really happening beyond the headlines, make sure to subscribe and turn on notifications. We upload new courtroom stories regularly, and you won't want to miss the next unbelievable case. Thanks for watching, and we'll see you in the next courtroom breakdown.